The Civil Rights Act of 1964 is a landmark piece of civil rights legislation in the United States that outlawed discrimination based on race, color, religion, sex, or national origin. It ended unequal application of voter registration requirements and racial segregation in schools, at the workplace, and by facilities that served the general public. Powers given to enforce the act were initially weak, but were supplemented during later years. Congress asserted its authority to legislate under several different parts of the United States Constitution, principally its power to regulate interstate commerce under Article 1, its duty to guarantee all citizens equal protection of the laws under the 14th Amendment, and its duty to protect voting rights under the 15th Amendment. The act was signed into law by President Lyndon B. Johnson on July 2, 1964, at the White House. Origins. The bill was called for by President John F. Kennedy in his Civil Rights Speech of June 11, 1963, in which he asked for legislation giving all Americans the right to be served in facilities which are open to the public: hotels, restaurants, theaters, retail stores, and similar establishments, as well as greater protection for the right to vote. Kennedy delivered this speech following a series of protests from the African American community, the most famous being the Birmingham campaign, in which students and children endured attacks by police dogs and high-pressure fire hoses during the protests against segregation. Following this, a wave of black riots swept the country in spring 1963, and the racial tensions moved Kennedy to action. Emulating the Civil Rights Act of 1875, Kennedy's Civil Rights Bill included provisions to ban discrimination in public accommodations, and to enable the U.S. Attorney General to join in lawsuits against state governments which operated segregated school systems, among other provisions. However, it did not include a number of provisions deemed essential by civil rights leaders, including protection against police brutality, ending discrimination in private employment, or granting the Justice Department power to initiate desegregation or job discrimination lawsuits. Legislative history. House of Representatives. On June 11, 1963, President Kennedy met with the Republican leaders to discuss the legislation before his television address to the nation that evening. 2 days later, Senate Minority Leader Everett Dirksen and Senate Majority Leader Mike Mansfield both voiced support for the president's bill, except for provisions guaranteeing equal access to places of public accommodation. This led to several Republican congressmen drafting a compromise bill to be considered. On June 19, the president sent his bill to Congress as it was originally written, saying legislative action was imperative. The president's bill went first to the House of Representatives, where it was referred to the Judiciary Committee, chaired by Emanuel Celler, a Democrat from New York. After a series of hearings on the bill, Seller's committee strengthened the act, adding provisions to ban racial discrimination in employment, providing greater protection to black voters, eliminating segregation in all publicly owned facilities, and strengthening the anti-segregation clauses regarding public facilities such as lunch counters. They also added authorization for the Attorney General to file lawsuits to protect individuals against the deprivation of any rights secured by the Constitution or U.S. law. In essence, this was the controversial Title III that had been removed from the 1957 and 1960 Acts. Civil rights organizations pressed hard for this provision because it could be used to protect peaceful protesters and black voters from police brutality and suppression of free speech rights. Kennedy called the congressional leaders to the White House in late October 1963 to line up the necessary votes in the House for passage. The bill was reported out of the Judiciary Committee in November 1963, and referred to the Rules Committee, whose chairman, Howard W. Smith, a Democrat and avid segregationist from Virginia, indicated his intention to keep the bill bottled up indefinitely. Johnson's appeal to Congress, the assassination of John F. Kennedy on November 22, 1963, changed the political situation. Kennedy's successor as president, Lyndon Johnson, made use of his experience in legislative politics, along with the bully pulpit he wielded as president, in support of the bill. In his first address to a joint session of Congress on November 27, 1963, Johnson told the legislators, "No memorial oration or eulogy could more eloquently honor President Kennedy's memory than the earliest possible passage of the Civil Rights Bill, for which he fought so long." Judiciary Committee Chairman Sulla filed a petition to discharge the bill from the Rules Committee. It required the support of a majority of House members to move the bill to the floor. Initially, Sulla had a difficult time acquiring the signatures necessary, with many congressmen who supported the Civil Rights Bill itself remaining cautious about violating normal House procedure with the rare use of a discharge petition. By the time of the 1963 winter recess, 50 signatures were still needed. After the return of Congress from its winter recess, however, it was apparent that public opinion in the North favored the bill and that the petition would acquire the necessary signatures. To avert the humiliation of a successful discharge petition, Chairman Smith relented and allowed the bill to pass through the Rules Committee. Passage in the Senate. Johnson, who wanted the bill passed as soon as possible, ensured that the bill would be quickly considered by the Senate. Normally, the bill would have been referred to the Senate Judiciary Committee, chaired by Senator James O. Eastland, Democrat from Mississippi. Given Eastland's firm opposition, it seemed impossible that the bill would reach the Senate floor. Senate Majority Leader Mike Mansfield took a novel approach to prevent the bill from being relegated to Judiciary Committee limbo. Having initially waived a second reading of the bill, which would have led to it being immediately referred to Judiciary, Mansfield gave the bill a second reading on February 26, 1964, and then proposed, in the absence of precedent for instances when a second reading did not immediately follow the first, that the bill bypass the Judiciary Committee and immediately be sent to the Senate floor for debate. When the bill came before the full Senate for debate on March 30, 1964, the Southern Bloc of 18 Southern Democratic senators and one Republican senator led by Richard Russell launched a filibuster to prevent its passage. Said Russell, "We will resist to the bitter end any measure or any movement which would have a tendency to bring about social equality and intermingling and amalgamation of the races in our states." The most fervent opposition to the bill came from Senator Strom Thurmond. This he called civil rights proposals, which the President has sent to Capitol Hill for enactment into law, are unconstitutional, unnecessary, unwise and extend beyond the realm of reason. This is the worst civil rights package ever presented to the Congress and is reminiscent of the Reconstruction proposals and actions of the radical Republican Congress. After 54 days of filibuster, Senators Everett Dirksen, Thomas Kuchel, Hubert Humphrey, and Mike Mansfield introduced a substitute bill that they hoped would attract enough Republican swing votes to end the filibuster. The compromise bill was weaker than the House version in regard to government power to regulate the conduct of private business, but it was not so weak as to cause the House to reconsider their legislation. On the morning of June 10, 1964, Senator Robert Byrd completed a filibustering address regrets that he had begun 14 hours and 13 minutes earlier opposing the legislation. Until then, the measure had occupied the Senate for 57 working days, including 6 Saturdays. A day earlier, Democratic Whip Hubert Humphrey of Minnesota, the bill's manager, concluded he had the 67 votes required at the time to end the debate and end the filibuster, with 6 wavering senators providing a 4-vote victory margin. The final tally stood at 71 to 29. Never in history had the Senate been able to muster enough votes to cut off a filibuster on a civil rights bill, and only once in the 37 years since 1927 had it agreed to cloture for any measure. On June 19, the substitute bill passed the Senate by a vote of 73 to 27 and quickly passed through the House-Senate Conference Committee, which adopted the Senate version of the bill. The conference bill was passed by both houses of Congress, and was signed into law by President Johnson on July 2, 1964. Vote totals. Totals are in yea-nay format. The original House version, 290 to 130. Cloture in the Senate, 71 to 29. The Senate version, 73 to 27. The Senate version as voted on by the House, 289 to 126. By party: the original House version, Democratic Party, 152 to 96. Republican Party, 138 to 34. Cloture in the Senate, Democratic Party, 44 to 23. Republican Party, 27 to 6. The Senate version, Democratic Party, 46 to 21. Republican Party, 27 to 6. The Senate version, voted on by the House, Democratic Party, 153 to 91. Republican Party, 136 to 35. By party and region. Note: Southern, as used in this section, refers to members of Congress from the 11 states that made up the Confederate States of America in the American Civil War. Northern refers to members from the other 39 states, regardless of the geographic location of those states. The original House version, Southern Democrats, 8 to 87. Southern Republicans, 0 to 10. Northern Democrats, 145 to 9. Northern Republicans, 138 to 24. The Senate version, Southern Democrats, 1 to 20. Southern Republicans, 0 to 1. Northern Democrats, 45 to 1. Northern Republicans, 27 to 5. Women's rights. Just 1 year earlier, the same Congress had passed the Equal Pay Act of 1963, which prohibited wage differentials based on sex. The prohibition on sex discrimination was added to the Civil Rights Act by Howard W. Smith, a powerful Virginia Democrat who chaired the House Rules Committee and who strongly opposed the legislation. Smith's amendment was passed by a televote of 168 to 133. Historians debate Smith's motivation, whether it was a cynical attempt to defeat the bill by someone opposed to civil rights both for blacks and women, or an attempt to support the rights by broadening the bill to include women. Smith expected that Republicans, who had included equal rights for women in the party's platform since 1944, would probably vote for the amendment. Historians speculate that Smith was trying to embarrass Northern Democrats who opposed civil rights for women because the clause was opposed by labor unions. Representative Carl Elliott of Alabama later claimed Smith didn't give a damn about women's rights. He was trying to knock off votes either then or down the line because there was always a hardcore of men who didn't favor women's rights. And the congressional record records that Smith was greeted by laughter when he introduced the amendment. Smith asserted that he was not joking, he sincerely supported the amendment and, indeed, Reid, along with Wahida Martha Griffiths. He was the chief spokesperson for the amendment. For 20 years Smith had sponsored the Equal Rights Amendment in the House because he believed in it. He for decades had been close to the National Woman's Party and its leader Alice Paul, who was also the leader in winning the right to vote for women in 1920, the author of the first Equal Rights Amendment, and a chief supporter of equal rights proposals since then. She and other feminists had worked with Smith since 1945 trying to find a way to include sex as a protected civil rights category. Now was the moment. Griffiths argued that the new law would protect black women but not white women, and that was unfair to white women. Furthermore, she argued that the laws protecting women from unpleasant jobs were actually designed to enable men to monopolize those jobs, and that was unfair to women who were not allowed to try out for those jobs. The amendment passed with the votes of Republicans and Southern Democrats. The final law passed with the votes of Republicans and Northern Democrats. Thus, as Justice William Rehnquist explained in Meritor Savings Bank v. Vinson, the prohibition against discrimination based on sex was added to Title VII at the last minute on the floor of the House of Representatives. The bill quickly passed as amended, and we are left with little legislative history to guide us in interpreting the Act's prohibition against discrimination based on sex. Desegregation. One of the most damaging arguments by the bill's opponents was that once passed, the bill would require forced busing to achieve certain racial quotas in schools. Proponents of the bill, such as Emmanuel Seller and Jacob Javits, said that the bill would not authorize such measures. Leading sponsor Hubert Humphrey wrote two amendments specifically designed to outlaw busing. Humphrey said, if the bill were to compel it, it would be a violation, because it would be handling the matter on the basis of race, and we would be transporting children because of race. While Javits said any government official who sought to use the bill for busing purposes would be making a fool of himself. 2 years later, the Department of Health, Education and Welfare said that Southern school districts would be required to meet mathematical ratios of students by busing. Political repercussions. The bill divided and engendered a long-term change in the demographic support of both parties. President Johnson realized that supporting this bill would risk losing the South's overwhelming support of the Democratic Party. Both Attorney General Robert Kennedy and Vice President Johnson had pushed for the introduction of the civil rights legislation. Johnson told Kennedy aide Ted Sorensen that, "I know the risks are great and we might lose the South, but those sorts of states may be lost anyway." Senator Richard Russell, Jr., later warned President Johnson that his strong support for the Civil Rights Bill will not only cost you the South, it will cost you the election. Johnson, however, went on to win the 1964 election by one of the biggest landslides in American history. The South, which had 5 states swing Republican in 1964, became a stronghold of the Republican Party by the 1990s. Although majorities in both parties voted for the bill, there were notable exceptions. Though he opposed forced segregation, Republican Senator Barry Goldwater of Arizona voted against the bill, remarking, "You can't legislate morality." Goldwater had supported previous attempts to pass civil rights legislation in 1957 and 1960, as well as the 24th Amendment outlawing the poll tax. He stated that the reason for his opposition to the 1964 bill was Title II, which in his opinion violated individual liberty and states' rights. Most Democrats from the southern states opposed the bill and led an unsuccessful 83-day filibuster, including Senators Albert Gore, Sr. and J. William Fulbright, as well as Senator Robert Byrd, who personally filibustered for 14 hours straight.